the Law and Crime Network. Michael Bryant here. Good to have you along. Nothing like a little bombshell on a Friday afternoon as we enter our final hour of coverage for you here. We just heard breaking news out of South Carolina where disgraced attorney Alec Murdaugh has pled guilty to a bunch of financial crimes he admitted to earlier this year. Total was 22. The years, it starts to get a little mind-boggling, but luckily with us to break this all down is law and crime correspondent Anjanette Levy. Anjanette, I have a headache. I didn't sign on for this kind of math, but the court helped us. Give us the breakdown. What happened today and how does that impact the rest of Murdaugh world?
Well, Michael, good afternoon to you. And they're saying now this is going to be a 27-year sentence total. And I don't believe this should be too much of a surprise to our viewers because Alec Murdaugh had actually pleaded guilty to very similar charges related to these financial crimes in federal court back in September. So he's already admitted to all of this. He admitted that he stole all of the money on the stand at his double murder trial. That testimony couldn't be used against him at this trial, but it doesn't matter. He's already said he did it. Everybody knows he did it. And so I guess he's just trying to clean up all of his legal messes because I think his main focus right now is that motion for a new trial on the murder case in which he's claiming there was jury tampering. So I don't think this should be a very big shock to people at all. He'll be sentenced formally in state court, but then also sentenced in federal court. And it's our understanding that he's been cooperating with federal authorities on a lot of stuff and basically revealing how all of this went down and who was a part of it. So I think there should be maybe a chill going down the spine of possibly some people in South Carolina, possibly some elected officials from things we've heard from some very well-connected sources down there in South Carolina.
What about time served? I mean, we've got federal crimes, we've got state crimes, we have the murder under state law. Where is he going to serve time?
Well, the state doesn't want to let him go. They want him to stay in state prison. I am sure he would really like to go to federal prison, but keep in mind, in state prison, he is basically in isolation. He's in a special wing of a prison where he is not really mingling with the general population. So he is protected in many respects. So maybe we'll see some deal worked out with the feds where he does eventually he is moved to federal prison, or he may stay put where he is in state prison. As I said, you know, the state officials really wanted to hold on to him. They don't want him going over to federal prison to serve his time.
Okay, so let's talk about the proverbial elephant in the room here, and that's the murder trial, because that's a whole different animal with the allegations of jury tampering on behalf of the court clerk. Where is that in the process?
Well, the state has actually responded to those allegations in writing, and they claim that the clerk of court, Becky Hill, is denying all of these allegations, that she actually filed an affidavit or signed an affidavit that was filed with the response by the state in the court saying, I didn't say these things that they're claiming I said. I think there's going to be an evidentiary hearing on this matter, Michael. I just think that there's some murkiness here. It sounds like maybe she was indeed having conversations with the jurors, because if you look at the state's response to Alec Murdaugh's motion for a new trial, there's a table they included in there. And in some of those tables, SLED agents interviewed some of these jurors, and in the table, they actually verify or confirm that she did make certain remarks that were referenced in the defense's motion for a new trial. So I think that there's a lot of he said, she said going on here. Also, we had heard, you know, I've said this on the air before, we had heard the night before the verdict that she was having conversations with the foreperson of the jury. We tried to verify that, but it's our understanding that she was talking to this woman. What the content of those conversations were, I don't know. I can't say that for certain, but she was having some sort of discussions with these people. And so some of the jurors say, I didn't hear it. Some of the jurors say, I did hear it. Judge Newman will not be presiding over that motion for a new trial. He has decided to recuse himself because the defense may very well call him as a witness in any evidentiary hearing that could possibly be ordered.
Okay, I don't want to let this go while I've got you, the expert on all things Murdaugh here. First of all, I do note that in the response to the claim of misconduct, there were 10 jurors who provided affidavits. Obviously, there are 12, and you're right, there's got to be a hearing. There are way too many unanswered questions here. The court has to get to the bottom of this, and then if they were to define there was some misconduct, I mean, what do you think the odds are of actually having a new murder trial?
I really don't know. That's a really high hurdle, Michael. We always talk about how it's really hard to get a new trial, especially on something like a murder conviction. Courts are really loath to overturn these convictions. But we're going to have a new judge presiding over the case. The South Carolina Supreme Court is going to appoint someone to hear this motion for a new trial. It's possible he gets a new trial. It's possible he doesn't. But I interviewed both Jim Griffin and Dick Harpootlian at CrimeCon back in September. And Jim Griffin was adamant. He said to me he will get a new trial. He said it might not happen because the local circuit court, the county court orders it. But it could happen at the appellate level. It could happen at the federal level. And you could say to yourself, well, that's just a lawyer representing his client and advocating very strongly for him. But he seemed very confident. He seems to think they have the goods. But I think an evidentiary hearing will really reveal what the truth of this matter is and whether or not a new trial is indeed warranted.
Yeah, I would be surprised if it's decided at the local level. But I think, just looking at the raw facts, if the allegations are proven, I think a new trial is appropriate because we're talking about some outrageous behavior that is truly jury misconduct. And when you start messing with juries, the system's going straight to hell. So it's going to be amazing to see it unfold. The judge, as you suggest, has recused himself from any matters related to the murder trial. Obviously, he sat in on the financial crimes issues today. Those should be off the books now. This makes things a whole bunch cleaner as you continue your coverage, Anjanette. Thanks so much. Always good stuff. We will keep an ear on this story, and I know you will keep us updated as things develop. Thank you.
Will do. Thanks, Michael.
You bet. Okay, let's go back into court. We're going to continue our coverage. Let's go right back in.
Waiver of filing any post-conviction relief as well as ordering restitution. You have reviewed those provisions and are fully informed and agree with those provisions.
I am, yes, sir.
Under the Victim's Bill of Rights, the court must ensure that the victim's Bill of Rights have been complied with. The state is well aware of that, as well as your lawyers. And the victims have the right to be heard prior to the official imposition of any sentence or the official acceptance of a guilty plea. Do you understand?
Yes, sir.
And so it's the intent of the court, assuming a factual basis is established by Mr. Waters or Mr. James, that the court will accept this guilty plea contingent upon the victim's Bill of Rights being satisfied. Therefore, any sentencing will take place at a subsequent hearing, which will be on November 28th at 10 o'clock. Do you understand that?
It'll be when, sir?
November 28th.
Oh, yes, sir.
Yeah, Tuesday.
I understood it wouldn't be today. Yes, sir. I understand that.
All right. And understanding all that has been stated up to this point, how do you plead?
I plead guilty, Your Honor.
All right. Thank you. You can be seated, and we'll hear from Mr. Waters.
Thank you, Your Honor. And again, I plan to be somewhat brief today. It is a lot to get through, and will be more detailed as to the specific mechanisms in which these schemes were conducted at the proceeding on November 28th. But we all know, Your Honor knows, of course, having done the trial, the murder trial that we did back in January and February and March, about Mr. Murdaugh and his family legacy, his family power, his family influence, and the influence that he exercised as a respected and powerful plaintiff's lawyer throughout the state, but particularly here in the 14th Circuit. And Your Honor is, of course, aware that after September of 2021, it was reported, of course, the firm announced that they had uncovered that Mr. Murdaugh had allegedly been stealing funds from clients, and that led to a whirlwind state grand jury investigation that started to uncover a decade-long course of conduct of stealing from clients. And I want to, first of all, I want to give thanks to the team that I have here, many of whom you see sitting next to me, those that you saw at the murder trial that have done such Herculean work on this particular case. I have my co-counsel here, Johnny James, as well as co-counsel John Metters, and our forensic accountant, Carson Burney, who did excellent work on this case as well. But also have Ryan Kelly here from SLED, who's just one of the many SLED agents who worked so very hard on this particular case. In order to delve through this morass of documents and financial transactions to ultimately paint the picture of what happened and what Mr. Murdaugh did and what he is now here admitting in a guilty plea that he actually did. But I want to say this, that the other people that I need to thank that is so important were these victims. And I can tell you, Your Honor, that at the beginning of this case, when I first got involved in late August of 2021, and we found out about these allegations and we started to investigate these financial crimes, and I sat down with some of these initial victims and asked them to tell their story, asked them to go in front of the state grand jury and testify and tell their story. And I heard over and over again, Mr. Waters, you don't know who you're messing with. I have to live there. And there was a palpable fear among those victims, and particularly the initial ones, about coming forward. And I told them, I said, you're not going to be alone, but we're going to pursue this to its conclusion, but I can't tell your story without you. And to a man and a woman, those victims, as I sat at a conference room table and looked them in the eye and had those conversations, agreed to come forward because that was the only way that this kind of abuse of the judicial system could be exposed. It's the only way that change could happen. It is the only way that we can ensure that this courtroom and all the other state courtrooms, of which those of us judges and lawyers and law enforcement officers and staff are part of, that it doesn't happen again, that it's not abused in this fashion again. And so I want to thank them, because that really showed true courage. And as the ball started rolling, more and more victims came forward, more and more became willing to tell their story. And as I talked to all of those individuals before they testified, the one thing, the one word that came out over and over again was trust. Was trust. It's what I heard over and over again. And I think that's the heart of this case. It is the trust that comes with having that law license on the wall. It is the trust that comes with being part of a powerful family. It is trust that comes with building a powerful practice. But it is also that trust that comes with the fact of how these schemes typically worked. And the way they worked is that when Alec Murdaugh would bring those individuals in to sign the paperwork, to look at a disbursement sheet that had out all the various disbursements that were coming from these cases, in most instances, he was still handing them a really big check. And it was easy for him. It was so easy for him to smooth talk and fast talk them through these disbursement statements because he's handing them that big check. And what they didn't realize was that at the same time, he was taking money from them, sizable portions of money from them, behind his back. And I think as we develop this case, that ultimately what it really boiled down to was such a sense of entitlement and lack of accountability that Mr. Murdaugh felt he was entitled to that money. And so he took it. We've detailed before how Mr. Murdaugh had some financial difficulties that started in the recession back in the late 2000s. And he had some financial difficulties, but after that he had some big cases, and his partners and those around him thought that those big cases, from which he generated large amounts of fees, sometimes 7 figures of fees, that he had gotten everything right. But he hadn't, because his insatiable desire for money meant that not only was he taking 6 and 7 figure fees, not only was he borrowing at very favorable rates from the bank, but he also was stealing from these clients on top of it. And the first one that's indicted by the state grand jury occurred in December of 2011. And that was from Natasha Thomas and Hakeem Pinckney. And those would be the crimes that are in 2022 GS 4701 and 02. And ultimately, he was able to steal from them with his first scheme. And that first scheme would be that he would have on the disbursement sheets, and those disbursement sheets are where it has the settlement and it takes out the attorney's fees and all the legitimate expenses and where all the money's going, and then the net result, the net amount that's going to the client at the bottom. It's an accounting of all how that money's being dispersed, that money that is going into his trust account that he holds in trust for those very clients. And the procedure is that you get those clients to go through that, you get them to sign it, which he didn't always even go through it with them, but the ones he did, he would put on there in the initial scheme, he would put on disbursements to Palmetto State Bank. And these disbursements to Palmetto State Bank were easy to talk through very quickly. Staff didn't pick up on it because they looked legitimate. It was not uncommon for Palmetto State Bank to sometimes loan money or to have claims. And so it was easy for that to look legitimate. And again, everyone from the clients to the people that worked in the firm, the people that were his staff, trusted him. They were not going to question what Alec Murdaugh said to do. And so that's how the first one went down. Natasha Thomas, there were checks made out from the trust account, made out just to Palmetto State Bank. And the first one was for $325,000. That was in December of 2011. There was another one that should have gone for the benefit of Hakeem Pinckney that was made out to Palmetto State Bank, and that's $309,581.46. And once he had those checks made out to Palmetto State Bank, he would then get those checks personally, or take those checks and take them over generally to Russell Lafitte at Palmetto State Bank. And then Russell Lafitte would willingly and happily then convert those monies on a PMPED trust account check made out to Palmetto State Bank and convert those to checks, to transactions that ultimately would go to pay the personal debts of Alec Murdaugh or into his account.
So there's Prosecutor Waters going through the very specific details of how Alec Murdaugh screwed his clients. And I'm telling you, I've been an attorney for 30 plus years. If you don't have that trust, if you abuse that trust with a client, you should go to hell. You should. And he's going to go away for quite a few years, having nothing to do with the murder case. That's a whole different animal. We're going to get back to this case and more. Got my guest queued up. We're going to take a break. Come right back. We are smack in the middle of a very interesting hearing taking place in South Carolina as Alec Murdaugh has pled guilty to 22 charges that could, if you rounded the numbers up, be about 200 plus years in prison, but they've boiled that all down to about 27 years. And so the prosecutor is itemizing for the court each and every victim so that the court can put the seal of approval on that plea deal. I should mention, you see the time clock going on there, 13 plus minutes. That is the Sam Bremer jury. They now have the case, and we will keep you posted on that as things develop on this Friday afternoon. In the meantime, joining me is Katherine Lizardo. She sticks around from last hour. She's in the Dallas-Fort Worth area. And joining us, Casey, early in Fort Lauderdale. So thank you guys for hanging around. I know with the breaking news with the Murdaugh thing gets a little dicey here, but I appreciate the effort to stick around. Let me start with you, Casey. What are your thoughts on this? As you know, we're still in the midst of maybe a retrial in the murder case.
Well, this plea to the financial crimes does not come as a surprise, considering he had already pled to it in federal court, but also he already admitted to it in the murder trial. So the time, obviously, it was a great deal for him because although it was 27 years, according to my calculations, he would only do 85% of that, so 23 years. But that's really a life sentence. He's 55 years old now. So 23 years, by the time he gets out, he's going to be close to 80 years old. So it makes you ask the question, was it worth killing your family because you ended up agreeing and pleading to the crimes anyway?
Yeah, you know, that's one of the motives that I never could quite understand, that he did that, killed his wife and his son to give him more time to get out from under these financial misdealings. It's unfathomable to me, but I guess I'm not, nuts. Katherine, we've talked about how these cases play off of one another because there was this theory the motive for the murders was the financial crimes. Now those are off the table. If this comes back as a murder trial, second time around, how do you see things kind of being reshaped, if at all?
Well, one, when they're talking about financial crimes, hopefully it's much more streamlined, because in the trial that we had for the murder trials, there were a lot of financial crime evidence that was presented that were.
Yeah, and anybody in that client relationship, whether it be medical, legal, it just makes me nauseous just to think what was going on, what he did with a straight face, and just continued, his evil ways without a thought. It's unbelievable. Okay, let's go back into court now. Thank you, folks. We're going to listen now to more of the prosecution, basically laying out the details that will support this plea deal. Here we go.
His accounts or to pay other debts that he had essentially converted for personal use. But that was not the only way that he was able to steal from them, because it's very common for law firms to withhold money from disbursement after they make that initial large disbursement to the client. They withhold money in order to satisfy any medical liens that may need to be paid out of the settlement. And it's also very common for them to then negotiate with the medical provider to pay some percentage lower than the actual lien. Well, what that does is create a very easy delta in the trust account from which Alec Murdaugh could steal. And in this particular instance, there was a money held back for a lien to Medicaid, and as soon as we figured out that's how it was working, we started to look at those delta and look at the expenditures that were there, and ultimately were able to find a check for $25,245.08, dated June 13th, 2012, that ultimately was also converted through use of making the check out to Palmetto State Bank, and then was structured for the benefit of Mr. Murdaugh with money orders and cash under $10,000. That again is December 2011. We move on, and one of the things that Mr. Murdaugh had done was have Russell Lafitte appointed as the conservator for two minors that had their relative had been killed in a wreck. And he started to have Mr. Lafitte cut loans at extremely, almost non-existent interest rates to him to keep him afloat, because what Alec also had going on was a constant velocity of money where he was constantly borrowing money and servicing debt. And to keep those debts alive, to keep those debts afloat, he had to keep that influx of money coming in, whether it came from his law firm, whether it came from stealing from clients, whether it came from new loans. And during that period of time, there was about $1 million of loans that Russell Lafitte wrote to Alec Murdaugh to cover various debts that he had, to keep debts from going bad, to keep them from going into default. And so that highlighted the need to continue to steal money from his clients. And so the next one that we had, and this would have been starting in February of 2013, but this would be where he stole $1.325 million from a case involving Arthur Badger and his deceased wife and their heirs. And this would be the crimes as it relates to 2022 GS 47-3. Ultimately, again, it was $1.325 million. And one of the things that Mr. Murdaugh did to allow him to do that was, when there are multiple plaintiffs, the defense attorneys, once they agree on a global, the civil defense attorneys, once they agree on a global settlement, often rely on the plaintiff's attorneys to allocate those monies among their various plaintiffs. And he allocated the money in such a fashion that the vast majority went to Arthur Badger, even though that really made no sense in the context of the injuries of the case. And so he still was able to give Arthur Badger a check, a six-figure check, that was a great result in what Arthur Badger was expecting, not realizing that the vast majority of that money, that $1.325 million, was ultimately going to be stolen by Alec. And at that point in time, he had the checks cut in about 9 or 10 different instruments, and again, using the method of having them made out to Palmetto State Bank. And ultimately, those checks then were deposited to give the illusion of regular payments on the million or so loans that had come from those other clients where he had Russell Lafitte appointed as the conservator. And again, that ultimately resulted in over $1 million of theft from 2013 to 2014. The next case that went on was an individual by the name of Dion Martin. And Your Honor, this would be the crimes that were alleged in 2021 GS 47-29 in Allendale. Mr. Martin had been injured in a wreck. And this is where we start to see the scheme change. And what Mr. Murdaugh did was take advantage of the fact that it's very common for plaintiffs' lawyers in the state to use the legitimate business Forge Consulting. And Forge Consulting is a business that matches defendants or their insurers with annuity companies to set up annuities or structures for the benefit.
I tell you start hearing all of the deeds done by Alec Murdaugh. 27 years, it's a gift. Let's take a break. We'll come back more in this plea deal hearing right after this.